Welcome, everyone. So to introduce our panelists, starting directly to my left is Ann Mackin. She's been a staff attorney at Greater Boston Legal Services since 1988. She's worked in the immigration unit there since 2003, and for the last 5 years, she has almost exclusively done special immigrant juvenile cases. Next to her is Elizabeth Badger. She's the senior attorney at the Boston office for kids in need of defense. She's worked in immigration law for the past 10 years in immigration legal services focused on representing non-citizen children, asylum seekers, victims of crimes, and persons in prolonged immigration detention. From 2010 to 2013, Ms. Badger taught in the Boston University School of Law's Immigrants Rights Clinic. And at the end is Patricia Tellis-Warren. Since 1997, she's been the senior staff attorney in family law unit at the Greater Boston Legal Services, where she helps victims of domestic violence through divorce proceedings, child custody proceedings, and obtaining restraining orders. She also gives counsel and advice to the immigration attorney and kind attorney, which is namely Anne and Elizabeth sitting here at the table. So they all work intimately together on these types of cases. And with that, I will turn it over to Ann Mackin.
So thank you very much for coming today. We're going to start with talking about who the kids are that are usually in these special immigrant juvenile proceedings. And when we do the cases, one of the biggest things, as in any case, is getting to know your client. And the special immigrant juvenile cases usually have 3 steps, 2 or 3 steps to them. But what makes you eligible to be classified as a special immigrant juvenile for USCIS is that you have what people call a predicate order from what is, quote, the juvenile court in your jurisdiction. In Massachusetts, the juvenile court, there is a court called a juvenile court, but there's also the probate and family court, which deals with many issues related to children. So in order to prepare to go to court, we often write an affidavit from the child or from someone in the child's family or who knows the child if the child's too young to do that, him or herself. And really, it gets to the heart of what the cases are about, because you really need to know the child and be able to tell the child's story or have the child tell his or her story in his or her voice. So part of what we're going to talk about in the beginning today is how do you interview a child client? What things do you look for? What are special concerns that you might have if you're interviewing an adult client? How is it different? And things that you might consider when you're interviewing a child. First of all, there's just some general things about how to make your interviewing child sensitive. And so you need time to build rapport with a child, creating an atmosphere of trust. A lot of it depends on, well, that's important for every child, but there's a lot in these special immigrant juvenile cases that you also need to be aware of. The kids that we see around here, a lot of them are from Central America, though we've seen a lot of children from various parts of the world, from Brazil, from all different countries in Latin America, African countries, Asian countries. They're really from all over, but most recently we've seen a lot of children from Central America. And kids come to the country in different ways, right? Some come with parents or with family members as a tourist, and then they stay. And other children come across the border because they haven't been well cared for, or they're fleeing some kind of violence or the gang violence in their countries, or a bad situation at home. They come for a lot of different reasons. So one of the first things to figure out is in what context your child arrived. And did they come and cross the border without permission? Did they come with a visa and get left here, or something didn't work out with whoever they were staying with? But if they're coming from Central America, one of the things that's also important is that to understand by the time you meet the child that the child's already been through a lot. You know, if they've come on that journey, it's 1,000 miles at least. Depending on what country you're coming from, it's extraordinarily dangerous. A lot of kids, at least in the past, have ridden on the top of freight trains, which they call the Beast, which is a very, very dangerous trip. It's dangerous through the mountains. It's just dangerous all the way. So first of all, they've arrived. Then if they've crossed the border, they very well may have been arrested crossing the border. After they cross the border and are arrested, they first are with the immigration, with the Border Patrol. Then they're often put into a detention facility or a shelter for children. And then they are placed either with a family member or a friend or someone else that the family knows who might take them, or someone they know, or they could be placed in some kind of foster care situation. That could also be true for children who've entered legally. They may not have been through the detention part of it, but they may have been with one person and then another person, and they may not, so their living circumstance may not be stable, or it might not have been stable. So by the time a child starts talking to you, you know, who knows what number in the line you are of people that they've already spoken to, already told their story to, and what shape that child is in personally, emotionally, how old they are, how much school they've had, what they understand, what their language is. Some of the Central American kids, English is their third language. They speak an indigenous language, then they speak Spanish, and then now they're trying to cope in English. And this could be any child of any age from 10 years old to younger or older, right? But so there's just a lot to consider about the kids sitting in front of you, what they've already gone through, and what's happening to them now. Are they in removal proceedings before the immigration court? Are they just meeting you on their own because they've been here a long time and they are in high school and they want to go to college, and lo and behold, they find out that they're not a person with status in the United States. They were left with a relative, and what can they do to try to get a legal status in order to meet their own goals in their lives? So looking at an individual context, looking at the family context for the kid. You know, do they live with family members? Did they live with family members they don't now? Why did that change? Who's taking care of them? Are they actually homeless? There's all kinds of things that go into that. And also then the social political context that they come from, their country of origin, religion, politics, cultural issues, gender issues, socioeconomic issues. There's just a whole lot going on, as there are with all of us, but in a different way with children. So another point is, so that's sort of a starting general place to think about working with kids. Then cultural competency is another issue, you know, and the kids that we primarily work with, Central American kids, but kids from all over the world who've made it here, and they want to go to school, they're going to school, they're doing well in school. You know, they've already been through a lot, but they also have a lot of strength because they've survived the journey if they came from Central America. if they're talking to you about special immigrant, or you're talking to them about it, then there's something else that's already happened with them and their family. But the kids we find a lot of them, although they have, issues just like all of us, they have incredible strength as well. So figuring out their strengths, their vulnerabilities, how they're resilient, what their issues are, and in the cultural context that they came from and that they're in now. Both of those things, all of those things are important. For kids who are connected in their own ethnic communities, there's a lot of, there's some, that's a strength for many of those kids. Some have religious and faith communities. Sometimes people have support at school. Sometimes they have families and friends or neighbors who are helping them. Economic issues is another thing to consider. Some of the kids work, some of them don't. So there's all of that going on when you're interviewing a child. So some tips about interviewing children. You might want to start with more neutral topics. There's a lot of do's and don'ts, like avoid compound questions, asking open-ended questions of, you said this, could you tell me more about it? Then what happened? Figuring out times of day. Giving supportive feedback to a kid while saying, it sounds like you're telling me this, or I don't quite understand this point. Could you help me understand it and explain it to me differently? Or if you need so also you want to be aware of what setting you're interviewing a child in, right? Because you need to have the child be comfortable, and it just takes a while to build trust. And for kids, why should they trust you after they've been through all these other people, and you're the one who's saying, well, I'm going to be the one to help you. So it takes a while for a kid to really trust that. Some kids really are desperate and they really want you to be the one, and some kids aren't so sure that you're actually going to be the person to help them. So you want to meet them in a private place, something that's not distracting, that's appropriate for the child's age, that's culturally appropriate. And you want to explain to the child in the beginning what it is, who you are, what it is you're doing with the child, and what kind of information you want to discuss with the child, so the kid has a sense of what you're doing with them and why. And you can make it more casual and fun, like we have at our office. It doesn't work for everybody, but we have lots of boxes of Crayolas, 8 Crayolas, and we have, and it's amazing, not 15-year-olds, but 12-year-olds. We have some 12-year-old kids who find it really comforting to sit and color, or just colored paper that they can draw, things that offer water or something to drink, or do they need the bathroom, just like you would for adults. They wouldn't color, of course, but but you want to make the kids feel comfortable and comfortable with you. Let's see. So also, the language issues are a big deal, obviously, and you want the kid to be able to tell you their story in the language in which they're most comfortable. So we often use interpreters. A lot of us speak Spanish, but we don't speak Urdu or whatever other languages there are. So it's really important to use a translator so that you get it while the kid's telling you the story, and you don't have to repeat unnecessarily to have them tell you the same thing over and over. You want to have somebody there that can help you understand what the child's telling you.
I'll just say a lot of the kids who speak indigenous language is, it's often a mix of Spanish and indigenous languages. And some kids won't admit that they prefer that mix, and it's not something that you as a Spanish speaker can accommodate yourself. And so asking if the child happens to understand any other languages might help you get at that language issue. And even when Spanish is told to you to be the primary language, if you feel like there's some misunderstanding, or perhaps a child is not being able to express everything, that should be a clue to you that perhaps you need to use an indigenous interpreter.
The other thing is reading. A lot of kids say that, have had school and they read, but even a lot of this can be very technical, and so even if you read in your birth language, if you write a child a letter or give them something in their birth language to read, you want to make it so they can understand it, or have someone explain it to them, because it's not really straightforward, a lot of this. Another thing about cultural issues is understanding what kids are telling you. For example, just talking about who's your mother, who's your father, what siblings you have. Different cultures think about family members in different ways. So, for example, I had a boy who told me that he lived with his mother, but I knew his mother had come to the United States when he was like 3 years old. So I was like, well, do you remember living with your mother? Oh yes, he remembered living with his mother, but who was he really talking about? He was talking about his grandmother, because his grandmother for him was his mother. And then something happened to the grandmother, and he said, well, he lived with his mother. And so I'm like, okay, did you live with your biological mother? No. Now he's talking about his great-grandmother, but he called them all mother, because that was the role that these different women had for him. So it's important. And other cultures we know, family members or cousins can be referred to as brothers and sisters. So because that's your relationship with them, you're a very tight-knit family. So you call them that, but then that's not their biological relationship necessarily. So you want to be understanding what the child is telling you about who they're speaking about, because down the line, if you get in front of an immigration officer and you haven't clarified it, then it can be seen as like not telling the truth, or they're calling somebody something that it's not who that person is to the child. And you don't want to end up in that position. You want to get the story straight. Other things to look out for are perceptions of time. And with children, that's often difficult, because maybe they don't know the calendar. Maybe their calendar is different than the Western calendar. Maybe they use a lunar calendar versus a solar calendar. Maybe they measure time by seasons of the year rather than by Monday, Tuesday, Wednesday, Thursday, Friday. Maybe kids sometimes don't know their birthdays because they were told it's one day, but they may not celebrate their birthday in their home country. So it's just things like that are really important to take into account when you're interviewing children, because what you really need to get to eventually is what happened to them. And and some kids are really willing to tell you right up front, and some are very shy about it. Some kids, it's a betrayal to tell you something that happened in their family that wasn't good, or because it happened to other children, they think it's really common, even though by our standards we might consider it neglect or abuse or abandonment even. They may say, well, their father went away or went and came back, and just so all of that's important. So also understanding inconsistencies in the story. Inconsistencies are natural. Some kids fantasize, they invent explanations about what happened. Some kids regress. Some kids emphasize issues that you think might not really be important. But kids have defenses to things that are really painful, just like all of us. And so you just have to work it through to figure out what a child's trying to tell you. Are they protecting someone? Are they protecting themselves? And go from there. Also, what developmental age a child is important, because some kids may be a chronological age that's older, but developmentally they may be a lot younger than their age, or they may have experienced things well beyond their age, which also impacts how you work with a child. So things that are just basically tips are using very clear language, explaining, not even using legal terms if you don't have to, but explaining concepts, because for a lot of kids, being court involved in the United States is something, first of all, they didn't even know courts exist. They don't know what they are. They don't know what's going to happen there, what's going to happen to them there, what a judge is, what a case is. What if you're looking for a guardianship for a child? Well, why would I need a guardian? Who are the players? And so eventually you want them to understand what their situation is and what you're trying to do to help them, but respecting what they want once they're able to tell you.
And I think that can be particularly difficult when a child has effectively been on their own
For a long time.
And suddenly you're telling them that someone needs to be taking care of them.
Right. Using language that's clear, like not using multi-syllabic words, using simpler language. Making sure that as you're going along that your child understands what it is that you're telling them. You can ask them, or what they understand about terms like punish or abuse. You may not want to ask a kid directly, well, were you abused? You want them to tell you their story. What was life like for you with your parents? Who was in your home? Draw me a picture of your house. What rooms were there? Who lived in this room? Who lived in that room? And where did you cook? Well, we cooked outside. We had firewood in the ground. We cooked in the kitchen. They call it a kitchen, but it's not. It's in some Central American countries, it's an awning that sticks off the house with poles, so the room's not enclosed because you're cooking with fire and firewood in the ground. Did you have refrigeration? Did you have electricity? Did you have running water? Or where did you get the water? Well, we had to walk 20 minutes each way to get water from the river. And how did you get it home? Well, we had to do that 4 or 5 times a day, or there was a well somewhere that we had to go to. So as you get into it and they feel more comfortable, they'll tell you what their situation was, and by asking for information instead of using categorical words like abuse or punish or things like that. What happened if you did something wrong? We would say punishment, but they would say, they'll tell you what the action was against them if they did something perceived to be wrong. Also, there's complications, like I was saying before, about relationships, like stepfather, mom's boyfriend, mom's maternal grandfather. Instead of using complicated labels, like you can ask about who they're related to. You want to, time estimates are really hard for kids, like what months did they go to school, or if you can get them to be really concrete about, well, when does school start for you? What month does it start? I don't know. Well, is it in Central America school? A lot of countries' school is from January to October. So, okay, well, when does the school year start? is it around Christmas time? Is it in the summer? Is it when it's hot? Is it, just to use different ways to ask questions. And about time. Is there some event that the child remembers about the particular time they're telling you about? You want to give time for the kid to answer you. You want, if you need to rephrase or ask it a different way. You want to try to stick to the topic unless the topic is so painful or so difficult, then you might want to back off and go back to something less difficult or less painful or that they can answer so you keep the rapport going with the child. And then you don't want them to guess about things if they don't have to. You can say, well, did this happen? They tell you one time, well, did something like that happen again? And go get this story out sequentially. Or sometimes people tell you the worst thing that ever happened to them. Or you can ask, what was the worst thing that, in these SIJ cases, what was the worst time, what's your worst memory of home, or your mother or your father? And what's the best thing that you remember? So that you're getting the range. There's just different ways to ask all that. So at the end, I think it's important to sum up with a kid about where you are and kind of say, well, this was very helpful today. This is the next step we're going to take. Or this is the next thing we have to do. Or I'd like to talk with you again at a certain point in the future. Or call me if you need something. Or call me if you want me to do X, Y, or Z. Because that's the other side of this, is that once kids start to trust you and rely on you, they may ask you for things that really aren't part of your role, your job. They call Elizabeth in the middle of the night when they're homeless or they have nowhere to go. Or they call needing all kinds of things, but you can clarify your role as you go along and try to hook them up with other people or people in their school systems or wherever that can address what a child's need is. And then there's the other things are things just about cultural things about us, like sometimes I've given kids an envelope, and we have self-addressed envelopes, and say, well, if you find this piece of paper, this is what it's called, just mail it to me. And then it dawns on me, well, what do you mean by mail it? They don't have mail systems. They don't know that the blue box on the corner is where they can put some envelope in and it magically gets to you. Just things like that. So you just have to take it, you meet people where they are and go from there. And it's great work because the kids they're really wonderful, and they really want the help. And they most of the time will be very happy to spend time with you and work with you to develop their story so they can tell what happened to them and you can guide that along the way. But eventually what you want to end up with is them using their voice and you using their voice and their words to tell their story so it belongs to them. And those are really the ways that once you use that and get to family court or juvenile court, it's the way that's the most compelling for the judges because it's not a cookie cutter operation at that point. You've told who the child is, and the judge knows what it was like for the child. They're there hearing it and standing in that child's shoes to make the determination about the child. So I think that's all I have for right now. Thank you.
Really quickly, now that we're going to start getting into the jurisdiction and options in the state courts, I just want to quickly poll the attorneys in the audience, since we're small. Which states are you from? Can we just start with the gentleman in the back here? State. Montana. New Jersey. Gentleman in the back? Iowa. Washington. Anyone over there? California? New Jersey, okay, that's helpful. I do have a lot of our presentation is going to be based on our practice in Massachusetts. There are similarities that I know of and differences that I know of in some of the states that were just mentioned. Most, if not all states, have some version of what we're talking about in your state courts, which is divorce, custody, guardianship. There are similar vehicles. They're not always called the same thing in your state court. The other piece of this is that in Massachusetts, like Anne just mentioned, we have the probate and family court together. In Rhode Island, for instance, there's a probate court and there's a family court separately. We also have a juvenile court here. In Vermont, for instance, I know that the family court does all the juvenile stuff, like delinquency, what we call a child in need of assistance, care and protection, which is essentially like a foster care case. So the point is that you need to know your state courts. Anne and I, as we I initiated my career in immigration law, have had to partner with family law practitioners like Patricia to get to know our state courts, which I think is a good way for anyone who's not already grounded in the state court practice to start these kinds of cases. So we want to know, just in terms of what we're going to overview today, is what does your state courts and which of those courts have jurisdiction over what types of cases, okay? The immigration statute at 8 U.S.C. 1101 827J says that we have to obtain what's called a predicate order that Anne referenced in the beginning from a state court with competency over juveniles. That just means juveniles is defined as a child under the age of 21. Now, we'll get to some of the issues of the gap in jurisdiction between the state courts, where their jurisdiction cuts off, or how they may perceive their jurisdiction to cut off for children, and that the federal law says that we may pursue this type of relief, special immigrant juvenile status, for children up until the age of 21. But that contradiction or conflict is something you want to be aware of in each of your state courts. But your state law then is what you're looking to define abuse, abandonment, and neglect. The immigration statute says that one of the things we have to prove is dependency, which we believe is the equivalent of jurisdiction. That reunification is not viable due to abuse, abandonment, neglect, or other similar basis under state law. So you want to look to see how those terms are defined under state law, as well as whether there are other types of reasons that a child may not be able to reunify, or that reunification is not in the best interest of the child. So, for instance, I was just in Vermont. They have very specific definitions of emotional neglect, sexual abuse, physical abuse, estrangement. They have all these different types of reasons that I think would be one of these other similar bases under state law. We in Massachusetts have definitions for each of the three items, abuse, abandonment, and neglect, mentioned in the federal definition. But we also have case law that defines further those terms. And then the final piece that the immigration statute says that we need to find, or that the state court needs to make a determination about, is whether or not it's in the child's best interest to return to their country of nationality and or their parents' country of nationality. Or last habitual residence, usually that's for children who are stateless. Those are, all the things that Anne was just talking about, how the child lived abroad, how he or she is doing here, the support or lack of support that they received in each of those places, how their lives are better, or at least different here than in their country of origin. Those are all things you're going to bring out in the best interest determination. And then the last thing we want to cover and really emphasize today are judicial concerns that are things like due process, that include service and notice and, you know, your presentation to the court. Those are this type of service and notice we're going to be talking about for immigration practitioners is not what we have to do in immigration court. So if immigration court, like myself, is your starting point, this is going to be quite different. But it's going to be of the utmost concern for the state court judges. And so we're going to get into that towards the end of the presentation as well. So to get right to it, I'm not going to spend too long here, but for me, these are some of my flags when I am interviewing my clients that will guide me towards what type of case I want to bring for my child in the state court. I think I often fail to mention, we're talking about causes of action in state court because there is no specific cause of action for these predicate orders or special findings. You have to find jurisdiction in a type of petition or complaint that the state court has normal competency, normal jurisdiction to hear. And so these questions here are a way to figure out what the most appropriate petition or complaint might be given your child's situation. So do they live with a parent or not? Are there parents in the United States or not? Are the parents legally married? There are different types of cases for unmarried parents and married parents when the child is living with one of the parents. Is a father named on the birth certificate? If not, maybe oftentimes that should be a flag. Well, paternity may be something I need to pursue for my client, a determination of who the father is. In other states, they call it parentage, acknowledging that sometimes the child's mother may be unknown. Is a child over or under the age of 18? That's going to clue you in as to whether, in some states, a petition in state court may even be possible given age cutoffs with jurisdiction, or whether you need to pursue one of the remedies that's specific to post-18-year-olds. What type of court order would most benefit the client? The client may be eligible, or it may be appropriate to bring a variety of types of cases, but what your client's priorities are would suggest what order might benefit them the most. And then lastly, if there is more than one option, having spoken to family court practitioners in your area, do you think that the court where you're going to be presenting your child's case might prefer one type of complaint over the other? These are very local issues, and that's why it's all the more important to be partnering or speaking with your local practitioners.
Hi, I'm Patricia Tellis-Waring. I want to just add a couple of things under judicial concerns. I'll just mention those as we go. I've been practicing in the courts of Massachusetts for 35 years. So a lot of that means I've moved around and saw a lot of counties, but also a lot of judges I know, so I can talk to them a little bit more casually sometime. And one of the things that is very important and going over all of you meeting your client and what you're supposed to look out for and trying to draft your pleadings is very important. One of the more recent criticisms I've heard from judges about the special immigrant juvenile cases that are brought into probate court is that they appear to have cookie-cutter facts. It's one thing to have a law that's, and you're cutting and pasting in terms of the law, but it's not very helpful, and it doesn't reflect very well on an attorney who does cookie-cutter facts. You really should try to do individual facts that go with your kid. So don't take somebody's pleadings and say, oh, this is what they said, let me change the name and change the date of birth, and it's the same. Judges know that. They really do. I mean, as the judge said, when you come in and you're from legal services, we know y'all take a lot of time with your pleadings, but we have private practitioners who we know are charging money for clients, and they come in here and all they have is the same set of facts that I've seen in another case, and they just changed the name. So they know that. They don't like it. They're insulted by it. And your client should be, if they knew that they would just having their name stuck in pleadings, they should feel insulted. So please take some time, do individual facts about your client, and don't, you can look at a case and try to say, I'm looking at things, a similar situation, but your client is an individual person, and you really need to remember that. The thing that I have always liked about the family court, which was not my ideal to start off when I started to practice law, but that you can take facts and have the uniqueness of them come out with a different result. So that even though someone else may have lost something, if your facts are really unique, you can argue that, well, that doesn't apply to me. The law doesn't apply on my set of facts. And the probate court is really good about that, because his family court and family situations are always unique and they always change. So that you can always say, my facts are different. And so probate judges are used to seeing facts that are different, and people arguing about my kid and my husband and my child. So they don't want to see cookie-cutter pleadings and facts on any case. The other situation is that one of the things I'll spend more detail talking about is notice. Probate and family court, because you're dealing with people who are always coming in saying, I didn't get notice, and you're talking about rights having to do with children, and you may be taking them away, or you may be curtailing their custody or visitation situations, which are fundamental things that parents enjoy. Judges really want to make sure, and they look at these cases as no exception. You gotta give good notice. You gotta let the other side know what you're doing. If you're saying this is against parents, you gotta let parents know what you're doing. So that's one of the other concerns they have about this. In terms of looking at what Elizabeth was talking about in factors in terms of determining the cause of actions and looking at your exact facts of who's the child with, how long has the child been with that person, is it really real when you say that the other parent did all of this? Take some time and look at that. It's really important to think about that before you decide what you're going to file.
So now Patricia's gonna start taking us through some of the individualized types of claims. I know that specifically, we mentioned California and New Jersey. In New Jersey, our venue, from what I understand from my colleagues in those states, our venues are pretty much limited to the family court. In California, it's a little bit more broad. California, the probate court does guardianship, the family court does custody support, visitation, paternity, divorce, separate support. I would actually say that division is quite common. That's what we see in Rhode Island as well. The juvenile court does delinquency, and they have a dependency and a separate adoption court. So those are just examples that I know of the states that were mentioned out here. What we're going to be discussing now are the claims that all take place in Massachusetts under the probate and family court. But as I mentioned, we do have juvenile courts here as well that would cover other types of claims, namely care and protection, a child in requiring assistance is what it's called now, and delinquency. So we're going to have Patricia take us through the probate and family type cases.
The first general overall thing that I just need to say is the politics of trying to do special immigrant and juvenile cases changes. Probate judges are people, and they listen to the news, and they have political sways one way or the other. And the atmosphere that we're currently in this country in terms of how we perceive and see juveniles, they all see that. They all have feelings about that. They have backroom discussions about it, so that you want to do these cases and you see the kids and you're very empathetic and you say how horrible. Well, you may be standing before a judge who doesn't see it like that. And you can't choose. Well, to a certain extent you can't. You can't just say I want a certain judge. In Massachusetts now you get assigned by docket numbers, and the docket numbers are whatever they go in that day. You don't know what you're gonna get because there may be this docket goes to this judge, the next docket goes to another judge. So it's very hard to plan to get before a certain judge, to have your case heard by a certain judge. So that when you're doing the cases, the overall thing is that we're telling you the different things that you can file in probate and family court. You may find you get before the judge, and they'll go, no, I don't like that. No, you shouldn't do that. No, go back and do this. And my general overall rule is that if you're standing before a judge who is at all sympathetic and looks like they may help, if they tell you to go and change everything to blue paper because they love blue, go change everything to blue paper. It is so much better to get what your client wants than for you to sit there and argue that, why am I doing this on blue paper, Your Honor? Yeah, just go put it on the blue paper. And it's just easier. So that's the overall thing. We can tell you that you can try these, but it may not work, and they may not work in each county. They may not work with a different judge in the same county. Courtrooms right next to each other have different fillings. One of the chief ones that I think most cases are used is guardianship of minor, and Massachusetts statute recently was amended in 2014. It's commonly used. The statute, when you file for guardianship of a minor, you have to be over 18. You have to be an adult yourself. The child should be under 18. So sometimes siblings take guardianship of their older siblings, take guardianship of their younger siblings. So the relationship does not matter. Generally, there are cases where the mother and the stepfather have filed for guardianship of the minor. There are cases where judges say, no, the parent should not be a guardian. There are cases where judges say, okay about that. It's a usual thing to do when kids are under 18. It's paperwork is very clear. There's a statute, put name, address, who wants to be the guardian. There are some other forms you file, an affidavit disclosing whether they've ever had any other court actions. With all filings in the probate court, you're required to file an affidavit disclosing whether there are any other actions with respect to the child. And you are also required to file, well, not required to file, but for most of the clients, we file affidavits of indigency, which means that you get the filing fee waived, and you also get the court to pay for service of process if you're allowed. So generally, people who are mass health or receiving any type of benefit, or there's the form says that you affirm that you can't meet your daily needs and you don't have enough money. So that's generally not something that anyone gives you a hassle about. But all of that needs to be done, and you get the guardianship, and it ends at 18. So that brings up sometimes one of the first conflicts with the person moving on to the next stage of trying to legalize their status, which is if you get the guardianship, it ends at 18. If you don't get all of the special immigrant findings done and go to the next stage at that same time, then you have the guardianship ends at 18. Immigration say you can still come forward at 21. What are you going to do now? So that's a gap. But if the child is under 18, you go into guardianship, you can go to the next stage, and that's not a problem. The statute does, yes, the child generally lives with the guardian. That's in 99% of the cases. There are rare cases when they don't. It is not mandatory or required, essentially, as a guardian, that the child lives with you, but you should. Judges are going to frown on it if you are coming in and say, I want guardianship of child A who lives over in the neighborhood on the other side of the street or with someone else. It's like, why isn't that person coming? So you may have to explain that, but there may be good reasons for it. So it's not necessarily true that you just can't file if the child's not living there. But it does mean you have to explain, because it's an unusual situation. So more than likely, most cases, the person coming forward to say they're going to be the guardian has the child living with them. And they may be a relative, they may be a friend, they could be an older sibling, it could be anyone. Anyone can be a guardian, by the way, so as long as they're over 18. With all of the cases in probate and family court that you file, anything having to do with children, you're going to be required to go to probation, and they're going to run a criminal records check or a CORI check. includes the 209A restraining orders. But that will be run on the guardian, that will be run on the parents, and, yeah, they will not be run on the child, but it will be run on the parents and the guardian.
And other adults living in the house.
Oh, yeah, all the other adults living in the household, just to make sure that there isn't something there. If there's anything there that raises questions, the judge will ask about that in court. If they have some concerns, say, sir, I see you have an outstanding warrant here. You may want to go clear that up. Or if they pull up a warrant and it's outstanding, they may have to tell you, if you could go upstairs and clear that up, or the court officer will have to hold you until that's cleared up. So that may be one of the questions you want to ask anyone who wants to be the guardian and anybody else in the household, is get some idea about what their criminal record is. And they can always send off and get a copy of it beforehand, so you can look at it and see what's on there. Maybe try to clear it up. It all depends on how much time you have. But that's another, just make people aware of that.
I'll say, so immigration status, this is a question that I think comes up in almost every case. Do I have to have immigration status in order to be a guardian? In Massachusetts, the answer is no. The judges care whether the child is safe with a safe person. It doesn't matter if they have immigration status or not. And it also doesn't matter when you're in removal proceedings, when a child's in removal proceedings, and they've been through what's called the Office of Refugee Resettlement, one of the shelters at the border, who then reunifies the child with an adult. That's how they get from the border to Massachusetts. There's some paperwork that they call the sponsor, the adult, has to sign to get that child released. That neither constitutes a legal guardianship, nor does it mean that that person must also be the legal guardian in the immigration, or in the family court guardianship case. For me, what I counsel kids is that the guardian should be the person you trust and that you want to live with, and that's taking the best care of you. If your uncle has status, but you don't really feel comfortable around him, but your aunt doesn't have status, and she's the one you live with and who supports you, then let's ask the aunt to be, your guardian.
And just following up on what Elizabeth just said, please know whether the person that's being proposed as the guardian and what their status is. Because it may come up. I mean, you may have 9 judges that will never ask, and you're gonna meet the one judge that will say, oh, okay, so I'm keeping this person. Well, wait a minute, does the guardian have status? Because I actually had a judge mention that was one of the questions that they wondered about, but had not asked anyone, and I figured sooner or later he's gonna ask someone. But so that, and you'll just have to be honest and tell the truth. I mean, you're officers of the court, so you have to tell the truth. So I think it's more of an issue if you don't know. You should know the answer. And just be able to let the court know that. They know that it's not required, but they may want to have the answer to that.
And I think a good way to not create, if you're doing this in a state that is new to this type of work, or in a court that has not seen a lot of SIJ cases, my advice to you would be to not create the false standard that guardians have to have status. While I say that the ORR sponsor doesn't have to be the guardian, a lot of times they are. And immigration does release kids very often to persons who are undocumented. And a response that I often make when I do get the question that Patricia mentioned is, well, Your Honor, immigration released the child to someone they knew to be undocumented, and they believed that that person was an appropriate caretaker, so we don't have any concerns given their undocumented status.
Moving on to actions between married parents. Massachusetts does not have common law marriage, so that no matter if you live together for 25 years, it doesn't get you very far. As a judge pointed out to me once when I said, but Your Honor, he's spending the money. She said, it's his money. I said, okay, she's right. They aren't married. They just have 2 kids. Okay, so just remember that. But in Massachusetts laws, chapter 208, settles divorce and separate support modifications. You can file any of those actions and asks for special immigrant findings under them. And as you know, you satisfy what you need to in the divorce in terms of just alleging what the cause of action is. And then under the special immigrant juvenile, you would have to show that one or both of the, well, I assume one of those parents, since you're doing a divorce, but that one of the parents is also has abused, neglected, and abandoned the child. So that, just think about those in terms of two different things you have to show. One of the things, just to be clear, Massachusetts has grounds for the divorce and they have irretrievable breakdown. The recent trend with the court is to make everything irretrievable breakdown. So I don't know if anybody wanted to use cruel and abusive as a cause of action, either to help with the abuse or abandon, but just let you know that the recent law is that even if you plead that and don't plead irretrievable, the judge can always say irretrievable. So I have all these cases that I really wanted them to find cruel and abusive on the last 2 years, and they all rejected that and said, no, we're just gonna do irretrievable breakdown for everybody. So that's what they're doing. And the divorce would just be divorce pleadings, and there's a whole packet, so do that. Separate support, the same thing. In Massachusetts, you can get legally separated and everything but remarried. And then you can also go in and file modifications of a divorce action. Some of the things that come up is trying to modify divorce actions from another country. Every now and then that comes up, and it's kind of unusual. Massachusetts statute does allow that. But you just have to make sure you get copies of the pleadings and say specifically what you want. Again, the biggest thing in this section or any of them is notice. And that's often a problem, not for the wife to be divorced from the husband or the husband to be divorced from the wife, but you do need notice if you're gonna do the special immigrant juvenile findings. You need to have an address that you should spend some time with the child, with the parents, and with the guardian, trying to find exact addresses, or as close as you can, exact addresses or last known addresses for people, because you have to give notice. That's one of the things the judges are very concerned about. They even become more concerned with these cases because more than often, more likely than not, one of the parents parts unknown. Or we're gonna say we don't know exactly where they are now. Or, they're living in Guatemala and we don't have an exact address and we can't get it delivered to them in hand, and somebody's gonna be there and tell them about it. So all of that makes them a little bit nervous. So make sure that you have done as much as you can to find out exactly where the parents are, where they last lived, where you would send notice. When you want the court to notify them of the divorce, notify them of the separate support or the modification, you should have an address for that. And so ask. Don't say, I don't know now, Your Honor, I'll go back and ask. That should be part of what your initial interview. You're gonna have to give notice. Make sure you take some time to look at it and get that. Actions between unmarried parents, that's Massachusetts laws, chapter 209C. In Massachusetts, as you know, unmarried mothers have sole legal and physical custody of the child, and you don't really have to go to court to get that established. You do sometimes for people who don't know the law, and you do sometimes for people who insist and have nothing else to do but act like they might be a lawyer. And that covers a lot of people, like the after-school people, the police officer, you name it. All kinds of people all of a sudden decide they can demand that you get a custody order because it's easier for them. But in the case that we have mother who's here and the child is here and father left the family before they even came to the United States, you have no idea where he is, and you want to go in to establish paternity when mother has sole legal and physical custody. So sometimes we are able to file that and get away with it, and without the court saying, why are you here? Mother has sole legal and physical custody. You don't need to come in and get a custody order. Or how are you gonna establish paternity and we don't know where father is and he abandoned the family several years ago? So those are interesting questions that we try and avoid if we can. but we do get them. So be careful about your situation. You can't, some judges will let you come in and do that. Some judges will just look at you and say, this is just a farce, and I'm not gonna go along with it. In terms of you filing a motion to establish paternity when the mother is here and you're saying dad's the bad person. So it's like, why are we doing that? If you can't find dad to establish paternity, if you can't, you don't need dad to for a custody order because mom is here. And one of the overall things is that the probate and family court is used to acting on certain statutes like 209C and 208 and the guardianship statute. They are not used to adding special immigrant juvenile as part of their work with those statutes. And so they are uncomfortable doing so. They much prefer straight out divorces, separate support actions, straight out guardianship actions. You start adding special immigrant juvenile findings and they're like, okay, was it ever meant to do this? So they actually like us to use standard kinds of causes of actions as opposed to trying something new. So, and they want standard kinds of requests from that. So when you add in the special immigrant juvenile findings, which is not standard to a lot of judges, they may ask, are you just trying to get around immigration? And often you have to explain your steps and say, no, this is not getting around immigration. This merely gives us an opportunity to apply for it. And just explain that. So this is actions between unmarried parents. They're not married. All right, they're not, not living together. So it's rather self-explanatory. If anyone had any questions, I'll just move along.
In a lot of other states, the support custody visitation is called parental rights and responsibilities, okay? Just so you can liken it to other jurisdictions. And all the past two slides about petitions, complaints where there are married and unmarried parents underscores this idea that the immigration statute asks for findings that reunification is not viable with one or both parents. That has been interpreted by the majority of courts and by USCIS nationally to say that if reunification is not viable with one parent, that's sufficient, meaning that the child can be living with the other parent and findings are still viable. The one state that has found to the contrary is Nebraska. New York and Minnesota have specifically found in favor of the language that findings against one parent are sufficient. Most recently, the New Jersey Supreme Court kind of took this middle road and refused to decide, saying, well, in every order, we're going to make findings against both parents. Reunification with mom is viable because mom now has custody. Reunification with dad is not viable because X, Y, and Z, and then leave it up to the immigration official adjudicating the case to decide whether those findings are viable. Previously, anecdotally, it wasn't a published decision, but previously a divorce case was not, a judge said, not a viable petition in the New Jersey Family Court to obtain these findings. But I'm thinking now, after this published New Jersey Supreme Court, that someone may be able to successfully try that again. Actions for children 18 to 21.
Well, I could just say about it that it really varies state to state because there are, in Massachusetts, because you're an adult the day you turn 18, you have, the question is, how do you go to court then for between an 18 and 21 when you're 18 to 21? And the options for doing that include possibility if the child knows the father, it's usually a complaint for a paternity because most kids know who their mother is. But if you're you can file a complaint to establish that a certain person is your father when you're over 18 in Massachusetts. Also in Massachusetts, you can file a complaint for child support actually until you're 23. if you're, meet certain requirements, like you're going to college or doing, doing an other educational program. But in other states, you can go to court until you're 21. For example, in New York, you can actually have a guardian until you're 21 years old. In Massachusetts, you can only have a guardian over 18 if you have competency issues or a disabled person. The other way in Massachusetts that we've sometimes brought cases for youth 18 to 21 is in what's called equity, but that's the success at that is uneven because it's discretionary relief, it's extraordinary relief, and some courts don't believe that these kinds of issues come under equity jurisdiction. So there's some back and forth about that with the judges. But the idea is, in whatever state you're in, to know what types of complaints might be available for someone up until age 21, because you may not have this jurisdictional problem that we have in Massachusetts between 18 and 21-year-olds.
And so one of the things you should do, I mean, I think Ann said this in the beginning, Elizabeth did too, is try to get to know, if you have to go into probate and family court, and that's not where you're used to being, and it's not like where you feel most comfortable at, try to talk to the head case manager or one of the assistant registrars that sits in front of the judge. I'm talking about Massachusetts. And just say, look, I have a special immigrant juvenile case. I want to do it on, I'm going to try to make a request for child support and have that be my underlying legal action that I'm going to do. What do you suggest? And sometimes they have suggestions. They may tell you, oh no, this judge hates those. He just turned down one yesterday. I wouldn't suggest you do it. So then you walk out of the court and see if you can find another day and find another judge to do it from. But that's like one of the, the best ways to figure out, because judges do different things. You've been sitting there and you have all your pleadings, and the judge looks at it and says, well, if you ask the father, who is a parts unknown in Guatemala, if he will pay $20 a week in child support, I'll allow everything. And so you get on the phone or you fax it over to him and you say, will you assent to this? And he says, yeah, and he signs it and sends it back to you. It's not worth very much, but he signs, and the judge says, okay, I got what I want, and he signs everything for you. I mean, and so you may have to just play it by ear, like I said, and do whatever the judge wants you to do, whether or not, if he's going to sign it, then you want a signed order. And so do that. But the judges are much more comfortable in doing things along the lines that they've always done it in. So they're much more comfortable to talk about child support, and child support requires, enhanced service. And so if the person assents, then that may be worth something, but judges' orders can only go to the borders, and there's no interstate picking up of child support. So anyway, so that's just one example of.
Yeah, no, you just mentioned, where you have one-parent cases and you're pursuing a child support case, and the absentee parent is outside of the forum state, be it in another state or in another country, be aware of the Uniform Interstate Child Support Act about how to gain personal jurisdiction over the defendant. I think our arguments of abuse, abandonment, neglect play directly into some of those provisions that are under the act. It's from what I've researched, it is, like it says, it's uniform. There's different, obviously, state chapters that have brought that into the state laws, but it exists, and the case law exists pretty uniformly. Really quickly about age-out issues for the states mentioned earlier. California, Colorado, DC, and Virginia, 18, my understanding is generally the age limit to state court jurisdiction. New Jersey, family court can extend the jurisdiction over a child in a custody matter, so custody, beyond the 18th birthday if the child is unemancipated. Ann mentioned about New York. Texas, we were seeing some success with declaratory judgments for 18 to 21-year-olds, But my understanding is that recently USCIS has been reevaluating the validity of those orders in a negative way. And Washington, the viability of cases for 18 to 21-year-olds outside of the foster care context is in question, meaning in foster care cases, and I think that's true for most states, jurisdiction can extend up until 21, but outside of that, we're not so sure. Okay. So, moving on to filing the petition, what happens when you actually get to court?
We're going to go through this because in case somebody wants to ask a question at the end. So you get all of you've met with your client, you have all of your affidavits from your client, from anyone else that you wanted, and you have all of your proposed orders, and you go over to the court, and you should have done your affidavit of disclosing care in custody and your affidavit of indigency, and you hand that in, and they okay it and allow the filing, and then they set a date for your hearing on your temporary motions. Sometimes you want to do filing and see if you can be heard the same day. If you're under the gun in terms of either the kid about to age out, either turn 18 or turn 21, whatever you're doing. So you may want to go in and say, can I be heard quicker than you putting this in the normal change of waiting for a hearing date? And I have to give the other side notice. Can I give the other side short notice and, alternative service? All of that you may want heard ex parte that same day you're filing. So you're going to have a whole new set of pleadings along with your request for a special. You're going to have a motion for a speedy hearing and an affidavit as to why you need a speedy hearing and a proposed order as to what exactly you want the judge to say and rule in terms of notice. And so that, you're often walking there with a lot of paperwork. It may not make you the most popular person coming into court, especially if you're doing it at 3:30 or 3 o'clock. So that my suggestion is that even though they may stay open till 4:30, they don't really like people after 2 o'clock. So you may want to try to get there at 10 o'clock in the morning, which is their position because they're all super busy, but they want you to wait from 10 o'clock to 4 o'clock to get it all done rather than you coming in at 2 o'clock and making them work until 4:30. So just keep that into it, and they kind of rule the world a lot in terms of whether your stuff ever gets done that day or you ever see a judge. So you may have to suffer a little attitude and what is it when they insult? Yeah, insult. Okay. But you walk in there with all your pleadings, and hopefully you'll walk out with either something that says everything is filed, and you now and then you pick a date for your temporary orders, because you don't want to wait for a trial on your pleadings, because you can ask for a temporary hearing, and you can get the special immigrant juvenile findings, and that's fine. And the case can come up to a final hearing whenever it wants to. So you've gotten all of that. If you've gotten to something that says, now I have to go out and notify everybody of everything I just filed before I come into court on a temporary order, then you rush from there to the FedEx place with all your pleadings so you can send them to someone overnight, express whatever certificate of receipt that they got them on the third day or something like that, and then you come back to court after notice and you set it down for a hearing. Or everybody's supposed to show up at the hearing. So that, it may be a whole day of in the court and a whole other day of just doing service. So prepare to take some time. It's not simple, and the clerks don't like it, and the judges may not like it, and the assistant people you may get there. So it's perseverance a lot on the advocate's part.
So I would just takeaways from what Patricia said. If you're doing this in a place where you don't have some predecessors who have given you a list of what needs to be filed, it behooves you, especially if you're running up to deadlines, to talk to the clerks ahead of time, say, what exactly do I need signed? There may be things that you need signed in Guatemala in order to file first, or that need to be sent to El Salvador as soon as you file. And there may be things that you can produce yourself and sign as the attorney, and there may be things that the guardian has to sign, and there may be things that the child has to sign. You just want to have all of that done. It's going to make things go a lot more smoothly once you get into the court. So knowing what all those pieces are, there's a lot of like formality type forms that they want you to include. That will make things go more smoothly. And I think in Massachusetts tends to vary. I practice in primarily one of 4 counties. It tends to vary a little bit court to court as to whether you can sit there and they will docket up your case right there, and you get a docket number, and then you get a judge, and then you get your indigency waiver approved, and then you can go schedule a motion date like Patricia said. Or if they just say, goodbye, I will send it to you in the mail, I always make up some excuse to say, I need this right now, I just traveled all the way here. And going all the way to Worcester or to Salem on public transportation is no small thing. And so I say, I traveled all the way here, I would really like my docket number so that I can schedule my motion date while I'm here. And usually they'll accommodate, not always, but sticking around until you have a docket number and hopefully a motion date will behoove you. Some people just walk out of the court and then they never hear from the court again. So know from the court what the next steps are in terms of follow-up.
And don't be concerned if your nicely typed pleadings, when they read them, they say, oh, do this. Just make marks,
White it out.
handwrite it in. It was my first as a lawyer when I started practicing. She said, oh, just scratch that out. Scratch that out, really? And just hand that in.
Yeah.
And not to mention you can handwrite out stuff. I mean, you can handwrite an affidavit, you can handwrite a proposed order, you handwrite out your affidavit supporting your speedy hearing that you didn't know you had to do a speedy hearing for, because guess what? The last 3 times you did this, nobody asked for one, but all of a sudden you're in a county where, oh no, you have to ask for a speedy hearing to get heard to see whether we're gonna say you can do alternative service. So just be prepared to sit there and just handwrite them out. There's no shame in it. Judge, legible handwriting helps. I'm sure the judges would like that. But those are things that go right to the judge for decisions. Speedy hearings go in, so they have to take them up under their rules and practices, and the judge is supposed to make a decision like within 48 hours, 24 to 48 hours, so that hopefully, you'll hand them up and the judge will get back and say, okay, you can do this alternative service, and and you just have to get it done in 72 hours or something.
Yeah, and courts differ a little bit on these types of administrative motions. So in most courts, in Massachusetts at least, the motion for alternative service, the motion for speedy hearing will be done administratively, meaning they'll do it. You won't have to present. In Middlesex, you have to go and present on these hearings. Sometimes they'll let you do it the same day. Sometimes you have to schedule it. Most of the time you don't know that. They won't tell you. And so the case will just sit, and then they'll call you, or you'll be like, hey, why didn't my case get scheduled for a hearing? And they'll say, oh, because you're supposed to present. You're supposed to schedule
Or you didn't ask for it.
Yeah, schedule a motion date to present on your motion for a speedier hearing.
That's true.
And so,
That
yeah,
sounds really
if you don't
speedy.
know
It
to
is.
ask, they
Right.
won't always give it to you.
Right.
So, pull it all out of the clerk while you're there in person. There are also a lot of courts that don't answer the telephone. So again, being there in person will behoove you.
Okay. Moving on to the last slide. I think we've already spoke about this. One of the biggest things that judges worry about is notice, due process, making sure that they don't give you something, like they aren't saying that dad's the worst person in the world and he didn't even know. So they would be terrified if dad showed up and said, no, they never gave me notice before you said I abused, neglected, and abandoned my wonderful children that I sent money to every week, including last week. So, just get some address, send it, make as much effort as you can. Tell the judge what you've done. Say, Your Honor, I called and I spoke to the sister. I called and I spoke to the aunt. There are no other siblings in the family. This is all the people requiring notice. For instance, if you're doing some things, the judge will say, who is the next aunt or who's the great aunt, and make sure you have, somebody gets notice about what you're doing. Sometimes you need affidavits from these people to say, yes, I know he's the father, or this is the person who's always said he was the father of the child. But anything about notice, make sure you give notice of what you're saying and what you're proposing to the court, and have addresses for the court. The hearings will be scheduled, motions and trials. You ask the judge, what you care about most is that initial hearing. So make sure you either know it's going to be scheduled or have a date when you leave court, and so you can avoid it sitting there while you're thinking that they're going to get back to you. And then on the date of the hearing, show up. Make sure your file is before the judge. Show up, yeah, make sure your file is before, look, I just finished a trial where the guy asked for a hearing and at the end waived cross-examination, okay? So I'm just a little confused about why people have hearings these days. So, yeah, and your client should be with you, and the proposed guardian of the person, or the parent, whoever it is. And you should, first thing, you check in and make sure your file is there, that all your pleadings are there, that if you file pleadings separately, doesn't mean they all end up in the same file on the same day. If you have more than one file, they may just send one instead of all of them. So it's up to you to make sure all those things are done. And then you stand there and you make your wonderful argument, and you keep arguing until the judge gives you what you want, or finds you in contempt. And you're gonna figure out that nice line so you don't be in contempt, but you make your strong argument.
And I will say, if the judge is looking at you and telling you, I don't know about this counsel, don't be afraid to politely but firmly say, Judge, what do you have an issue with? Or what are you not finding, what standard are you finding that my client doesn't meet? You wanna create a record. And because if that record doesn't exist, appeal is going to be harder. You wanna force the judge to answer your questions, answer those questions about the requirements of the statute. Like Patricia said, this can get kind of political, and some judges I found don't want to grant cases, but can't articulate why. That makes for a good appeal. In Massachusetts, it's unusual that we have a full evidentiary hearing on these issues.
Yeah.
There are a few exceptions to that. That is not true in most states. I think we're on the easier end of that, in that counsel is making representations normally based on a sworn affidavit. Certainly that would be a different case if the case is contested. I have a few contested cases, and we do evidentiary hearings.
Okay, I just had.
But the judges also say, sometimes they ask if the kid's a little older and has written something, they are sworn in, and the judge will say, is this your statement? Did you help prepare this? Is this what you want to tell me? And is everything you've said here true? And act so that that's on the record for the child saying, yes, everything is true, or that they want to say something else once you get there.
And unlike immigration, the family court doesn't want an affidavit from a 5-year-old. So if that's your situation, the person with personal knowledge about the abuse, abandonment, neglect, about the best interest should be producing the statements that you're giving to the court, whether that's orally or in an affidavit. So it may be the parent, it may be the guardian. It doesn't have to all be coming from the child.
Okay. And one thing I want to say is that you may go into this initial hearing, and at the end of it, the judge still says, well, I want you to do this, I want you to do that. So maybe you have to go back again, and that's okay. You just want to make sure you keep in mind your deadline. Like if the child's turning 18 in 3 weeks, you want to make sure that second, whatever the judge does, says, Your Honor, can we just have this in 1 week instead of waiting for 3 weeks? But they may have you go do something else. And my advice is try to accommodate the judge as much as possible. You can't judge shop, so you aren't going to be able to say, I'm going to find another judge on another day because they assigned them to that judge. So, the judge may say, you know what, go back and get another affidavit. Okay, you have to run it. Go back and do some more notice. Go do that. And just see what you can do, whatever the judge wants done, okay?
It also varies in terms of orders sometimes, because the way we do it usually is pretty much a one-page order that meets the criteria of the statute, but some judges want you to rewrite the order, the proposed order, with more facts about the situation. And so that varies in court to court, judge to judge, jurisdiction to jurisdiction, so.
Now, do you all have questions? Does anyone have any questions? Yes.
I practice mostly in building family court in Mass. So this is everything you shared has been really interesting. But how much of your work with these special immigrant juvenile status cases is it in PFC? How much of it is juvenile courts or other?
So, do you want to repeat the question?
Yeah, the question was how much of our work, I guess personally, is, or do we know in Massachusetts, is in the probate and family courts versus the juvenile courts where there are, like I said, there are delinquency, CRAW, child requiring assistance, and care and protection. I would say the vast majority is in the probate and family courts. Partly that's because the cases that, I mean, I think that partly that's because the cases that we file, well, we're in control when we're filing the cases in the probate and family court. If it's in one of the other courts, it's usually because the DA's department has like initiated a delinquency case. DCF, Department of Children and Families, has initiated a care and protection or a truancy case or a CRAW. And so when we have kids coming to us, there are exceptions. I know that Ann and I, when literally we need the assistance of DCF because our child is homeless and we have to get DCF involved. But those are minority cases. And so I think by virtue of the circumstances of how clients come to us, most of our cases are in the probate and family court. I think in other states, I've done this in Massachusetts, and I would advocate with people in other states to get involved with your DCF attorneys and your state public defender's offices to let them know that these types of orders and motions should be being done in the context of CRAW and delinquency cases. The judges may be a little more, remiss and need some education about their exclusive jurisdiction to issue these findings, but it's in fact like a foster care, a CRAW, a care and protection is a huge opportunity for these kids who this may be like the only time that they cross paths in their lives with an attorney. I can't tell you how many young post-21-year-old folks I've met that have gone through one of those proceedings in their lives, had the opportunity to get special findings, met every single requirement, but no one in the universe of the court or the attorneys that the court appointed for them knew to do special findings, and they missed that opportunity.
Any more questions? I'm sorry, did we answer your question? Okay. Any more?
Okay,
All right.
great, thanks very much.
Thank you for coming.
Thanks a lot.
They gone?